Hello, my name is John Mayer, and I'm the Executive Director of CALI, the Center for Computer Assisted Legal Instruction. The video you are about to watch is from the annual CALI conference held at the University of Michigan School of Law in Ann Arbor, Michigan on June 4th and 5th, 2026. Most U.S. law schools are members of CALI. CALI publishes over 1,400 interactive tutorials that teach the law to law students. Faculty can also use LessonLink to create formative assessments using CALI lessons. CALI publishes casebooks by paying law faculty to write and review books that can be adopted in many courses in law school. These books are free to download from our website, or print versions can be purchased at near cost. You can download the PDFs or even the Microsoft Word versions of most of our books and add your own commentary before distributing to your students. $300 casebooks are a thing of the past, and adopting one book from CALI saves you more than your entire institutional membership. If you would like to learn more, email me at jmayer@cali.org. I would be happy to visit or zoom into your school to talk about CALI.
I think that means we're on. Hello, everyone. I am sorry to say that my co-presenter, Nicole Phillips from University of San Francisco Law, was unable to make it. Now, I put in a proposal for a 15-minute presentation. So, one, this is going to end pretty quickly. Two, I want this to be an interactive session. I'm going to assume that most of you do what I'm going to be talking about in this presentation. Feel free to test drive it. Feel free to give your differences of opinion, whether or not you've done this and you've rejected it, or you have a different way of doing things than I do. I would love to hear it in order to improve my own practices. And if you decide you want to light out and go to one of the full sessions, I will not be hurt. But that said, let's get started. If you can't be a good example, then you just have to be a horrible warning teaching legal AI literacy with real-life court filings. I think we all know the fellow on this slide, Stephen Schwartz, who was the lawyer who used ChatGPT and introduced AI-generated errors in a legal filing for the first time that we know of. Aha. So we have a basic agenda. Why use court filings? How to use court filings, or should I say how I use court filings in my advanced legal research class. How to find cases for these sorts of exercises. Caveats of using real-life cases, and then at the end, hopefully some discussion, questions, etc. Why use court filings to teach AI literacy, or at least why I do? I believe it's never a bad idea to integrate court material into a legal research or any skills class, and I have yet to hear why it would be a bad idea to do so. I think it's also useful showing students the stakes involved in regards to AI fabrications, that it's not just getting a minor scolding, that there are real consequences. And then, of course, emphasizing professional responsibility and ethics in legal research, which is something that's not typically done in professional responsibilities class. But I believe it should be done whenever you teach legal research, that there is an ethical component, that there is consequences that relates to the rules on professional responsibility in whatever jurisdiction you're in. It also applies to how you should complete your research. I find that actual court filings emphasize a lot of useful things. One, how these fabrications or hallucinations get integrated into legal documents. It's especially useful in showing that right now, no matter what any particular vendor may say, and they've stopped saying this quite as loudly, that there is no error-proof generative AI system for legal research or for general research out there. I believe that these court filings can show where lawyers and firms are failing to verify outputs from generative AI systems. It shows how judges are emphasizing cases and professional responsibility rules for their jurisdiction that apply to how lawyers should treat citations in their legal documents, and also how the problem of AI fabrications in legal filings is confounding and infuriating judges and is affecting the justice system as a whole, as well as the increasing sanctions against attorneys. Lawyers are losing patience, and the worst that lawyers do in try to cover up or paper over their mistakes, the madder judges are starting to get. We're starting to see fines in the tens of thousands of dollars. We're starting to see fines. There's at least one court that had lawyers pay fees and fines over $100,000. We've seen several lawyers who have already been suspended for the practice of law for at least 6 months in multiple jurisdictions. So this is a problem that unfortunately is growing rather than reducing. How many of you already use actual court filings in your class? Not as many as I thought. Can I ask someone who doesn't, why not? Anyone? Yes?
I don't know where to put it. I don't have time to squeeze it in.
Okay. So lack of time. Anyone else? Would you agree that most of you is just like, I'm already covering everything I can cover, trying to figure out another place to put it in is just too much? I get that, and I'm not sure that I really have a solution to that. And I admit, it's hard to squeeze in. I managed to do it just because I'm that passionate about it. So for using court filings, you can make it part of their general class readings. If you're already covering ethics, you can give them a reading on one of these cases, either a show cause order or an order for sanctions. But you can also consider how to make it stick. You can address it in your lecture. You can make it part of class discussions. You may want to make it part of in-class exercises. Maybe you want to do a quiz based on the reading that teases out what you want them to take out of the case. You may develop your own hypothetical that is based on a real-life filing. And then you can also do what I call verification exercises. So using court filings for ethical readings, showing students how responsible AI use correlates with specific attorney rules. I like to tie this back, particularly for the 3Ls who are studying or have already studied professional responsibility, how these rules tie into legal research, particularly when you're using generative AI. So the Rule 1.1, duty of competence, Rule 1.6, duty of client confidentiality, Rule 3.3, duty of candor to the tribunal, Rule 5.3, duty of supervision over non-lawyers, which also applies to software and applications. And I should say that at least most jurisdictions, including mine, which is California, for Rule 1.1, the duty of competence includes the duty of technology competence. And right now, there is a bill. I don't know if it's been passed yet. I don't think it's been signed by the governor. It may have been passed. That would require verification of AI inputs as a demonstration of technology competence. That's a new comment that may enter into the California State Code. And that would be for both attorneys and arbitrators, interestingly enough. So unfortunately, as I mentioned, these cases are increasing, not decreasing. So it's more possible and even easier to find a case that will cite your state's professional responsibility rules and your state's bar association guidance on how attorneys should be using generative AI effectively and ethically. Verification exercises. If you decide you want to try and do this, you just find a case you want to focus on, redact identifying information, and I'll talk about why when we get to the caveat slide. Make sure to give them explanations on the type of AI fabricated errors and the tools and methods to find and verify or fix them. And so the next couple of slides are from my ALR class, where I actually talk about this as part of my lecture. I teach a class, so in ALR, I have a module that I call Data in Legal Research. And that's where I address both data analysis tools, like context, like Lex Machina, et cetera, and I also address AI, both extractive and generative. So they get an overview of the types of errors that tend to happen with these tools. I teach them how to deal with hallucinations. The graphic is from my friend Rebecca. Do not trust, verify. And then I tell them what actual tools they can use to verify their citations. What works for citations, what works for finding fabricated quotes, what works for finding misattributed or fabricated propositions that may have been done by AI. How to find cases if you're actually interested in tracking these things. And you don't have to be. As it happens, I have a legal tech newsletter, so I'm interested in tracking these things, not as obsessively as other librarians, but I like to figure out what's going on in the world. So legal newspapers, especially law.com, Law 360, et cetera, are good sources. Alerts in legal newspapers and docket systems. So I have alerts set up on Bloomberg Law, on law.com, a couple of other places that let me know, oh, there's a new filing for a show cause order regarding generative AI, or a new order regarding sanctions over generative AI. And then there's social media. There are lots of lawyers and legal professionals, including law librarians, who post about AI fabrication hallucinations. My favorite is Mary, who is a librarian for New York State Law Library, I believe, or sorry, New York State court system. And she posts a lot about AI hallucinations and fabrications in legal dockets and the sort. There's also a lawyer on Twitter/X. He is an attorney, specializes in trademark issues, but he has developed this sort of side hustle in tracking cases where there are AI hallucinations in court documents. And then on Blue Sky, if you've abandoned X/Twitter, it's a very whimsical name, Mrs. Detective Pikachu Esquire. She is an attorney, and she does very interesting, very long threads about attorneys who get in trouble with AI hallucinations. When she does this, it's really fascinating to watch. How do you find cases if you're not interested in tracking them yourself, if you're not as obsessed as I am? There is a very famous tracker done by a French attorney by the name of Damien Charlton, AI hallucinations case tracker. It is very useful. It allows you to track, to filter by jurisdiction. You can track by party, alleged to have erred, so it'll help you filter out if you just want to look at pro se's, if you just want to look at attorneys, if you want to look at cases where the attorney said, oh, my paralegal did this. I realize it's still my fault, but it wasn't me who actually introduced the errors into the document. You can filter by the type of error, whether or not it's based on a fabricated quotation, or if the citation is wrong, or if the proposition is wrong, whether or not there's a monetary sanction, and whether or not there's been a referral to the bar for potential discipline. You can also search to see whether an AI tool has been specified. So if you look at Damien's list, if you type in Westlaw, it will tell you all the cases where the attorney said, I used co-counsel, I'm not sure what happened, or, I was using Claude, I just had to do some grammar checks, and suddenly this happened. So that can be useful. And it's a way to see how these errors, again, are not limited to just general purpose generative AI. There are plenty of cases where the attorneys were using Protege or Harvey or Vincent AI, et cetera, et cetera. Perhaps not as many as ChatGPT and Claude, because most of the cases, to be honest, in this tracker are done by pro ses. That said, attorneys make up probably a third, if not 40%, of the cases in this tracker. So it's a way to emphasize that the legal profession is certainly not, I should say, this legal profession is certainly implicit in causing and dealing with this issue, making this almost a crisis for certain judges. So one major caveat that I want to mention, if you decide to do this and you're picking a case, you don't want to pick a case that is too famous. Basically, if you pick a case that's easily Googleable, it makes it very easy for your students to just find the show cause order or find the sanctions order and grab the answers from there rather than actually doing the verification themselves. I got lucky. Some lawyer friends of mine pointed me to a Reddit thread where an attorney in my jurisdiction was bragging about how many errors his opposing counsel made and how he was going to destroy them in his reply brief. And he then offered to send people redacted versions of his reply brief and the opposing party's brief that had the errors. So I took him up on that. And so far, this case hasn't become famous enough that it's not in Law 360, it's not in law.com, and more importantly, none of the filings are in Westlaw yet, since Westlaw doesn't cover all filings. So the students can't just do an end run around the process of verifying. This is something I've recently realized, and I hope to sort of integrate into my next version of ALR. State appellate courts that have their hearings online are starting to address these issues in oral argument. So you can see the judges reacting in real time to attorneys who have AI-introduced errors in their legal filings. So, and it can also be a great illustration of how both sides have a duty of competence and candor towards the tribunal. There's been several cases right now, one in my jurisdiction, one in New York that I've recently seen, where the offending party that introduced the errors got in trouble, but it was the court that found the errors, not the opposing side, and judges aren't wild if they have to correct the opposing side as well. It shows that the opposing side wasn't doing their due diligence in checking the citations either. And so in one case, in the California case regarding a dissolution of marriage and custody of a dog, for real, basically one side gave a brief arguing for something that literally included a false citation that someone grabbed off of Reddit. And that went through. The opposing side did not oppose this, did not let the judge know this case doesn't exist. These cases don't exist. They're wrong. And it ended up in the trial court's in trial court's order. And so when they got to the appellate court, they found, oh, these cases don't exist. They tried to argue these cases don't exist. And the appellate court basically said, you could have done this at the trial court level. Why didn't you? Thus, we're going to let the trial court order stand. So you have bad law, and hopefully that bad law will be limited to just that case. But you can see the consequences of, yeah, you're losing your case because your lawyer was too lazy to verify everything. And I think that's an important lesson for legal research and other aspects of legal practice. 19 minutes, all right. I see a question, yes.
It's actually a comment. I'm glad to see that you saw the same Reddit post that I did. It was fascinating to watch live.
Yes.
I'm not sure if you saw, this was last year in New York. There was, I think he was actually an attorney. I don't remember if he was pro se or not, but he generated video for his oral argument.
Yes.
Using AI, and was very much told off, and there's a video of that.
Right.
And so I showed that to my class as well to show, again, like you think you're being clever, and people really are not receiving it well.
Right.
That, in case you haven't seen it.
I have seen it, and it's really interesting, particularly in the A to J context, where people, it's like, well, if you can't afford an attorney, how should, what tools can you effectively use? Why shouldn't you be able to use generative AI if you don't have, professional legal help? It's not fair that you can't use this tool. On the other hand, and judges are pretty lenient about what you can do, and there's been some interesting discovery orders about whether or not people have to disclose this tool, whether or not they have to share their inputs, and under what circumstances. So that's all interesting to me from how these tools integrate into a general law practice. I haven't brought it up with my ALR class. It's a little tangential, but it's something that I think we should definitely talk about as a profession in terms of promoting access to justice, and to what extent the public are using these tools. So how can people who care about access to justice help them use these tools effectively and ethically as well? Thank you. Yes?
Are you also looking at separate?
I know there's a couple of instances for judges in, I want to say the Fifth Circuit, the Sixth Circuit, in the South, I know, and Senator Chuck Grassley basically slapped their hands for using generative AI, because it turns out there were AI-generated errors in some of their orders as well, because they hadn't carefully verified, or had their clerks carefully verify everything too. So there's been warnings for both state and federal judges about to be careful whether or not you use these tools. There are several judges, mind you, that are really enthusiastic and really love these tools. Both Rebecca and I know a developer that has been selling judicial AI tools in several places. I know where I am in Los Angeles, the LA Superior Court is now using a judicial AI tool to help them brief their cases. So we don't know how effective it is. We haven't heard about any blowback, but this is definitely something that's being integrated at multiple levels throughout the system. Yes.
From a student standpoint, so we have been, introduced to court opinions where something has been hallucinated. As a student, do you think it would be beneficial to, introduce them probably to a law article or something of a law student that's gotten in trouble for using AI? Do you think that's a little too?
I have not seen any yet. I'm sure there might be some out there, and I'd be interested in seeing what develops and under what circumstances that they do. I've seen one interesting student article that worried about de-skilling and what's known as cognitive offloading, whether or not over-relying on these tools will actively prevent them from learning the skills that they are in law school to learn. That's the major one that I've seen from a student perspective. I haven't seen others. But I should probably look more at maybe like National Law Journal and other publications. You want to scare them a little enough to be cautious. You don't want to paralyze them with fear. So, and the way I try to teach, and so far my evaluations seem to be more on the positive side, is be careful but be curious. Or should I say, be curious and careful. So consider how to use these tools strategically, effectively, and ethically. So that's my emphasis, and I think it's working. I have no guarantees. Doing surveys on students nowadays, unless you promise them something like a Starbucks gift card, can be diminishing returns. Any other questions? Or yes?
I was wondering, I guess this kind of relates back to the last session that was in this room, one about like over-reliance on algorithms. But I guess, so my question is, it is very easy for me looking at some of these things to be like, wow, I cannot imagine ever even filing something that looks like that. Like sometimes the mistakes in the oversights are so glaring that I wonder how you counterbalance the fact that a student might look at this and be like, what a dummy, I would not do that. When in fact there are other situations where students who are, where people who are absolutely not dummies have done it for various, like, I'm in a huge rush, I'm having various, like, how do you balance that by showing them things that are pretty glaring, but not so glaring that they're like, I'm not that dumb?
I think sometimes the errors that show up can emphasize that. You know, there are parts where it's just like, this doesn't exist. It has never existed. It came out of the clear blue sky. And then there are places where, oh, yeah, it just got like part of the file name, or got part of the case name wrong, or it just got part of the citation wrong. And then you have the more interesting errors where, yes, the case name is right, the citation is right, it exists, but the proposition is completely wrong. And that's where students can really get thrown off by, you know, okay, this case exists. Is it saying what I think it's saying? And that requires like a closer reading.
And I guess that's also building up the hallucinations.
Yeah. Yes.
So I just, I have done an exercise with students where I make them like find citations, like basically check a brief in real time. It's actually like a little game where like one side of them inserts the hallucinations and then the other side of the room has to like find them. And they have to do it under like a real time pressure. And at the end of that, they came out being like, oh, okay. Like it is really hard to do, especially in time pressure, which is a lot of these cases, like you look at the background and it's like, oh, it was a midnight filing and we were changing it right up until 11:55 or whatever.
Right. And I think another thing you can emphasize, one of the things I've started to emphasize, and I've heard it a number of times in this conference, there's all this student research that's being done at University of Minnesota School of Law by Daniel Schwartz and various cohorts. And what he tends to emphasize is that by over-relying, even the A students can worsen their performance, while the C students can better their performance. And the other thing is that you tend to make more mistakes when you're under time pressure and when you're cognitively fatigued, which often at the same time, and happens a lot to lawyers. Does that mean you shouldn't use AI at all? No, but it shows that you should be more careful than not, particularly under those situations. Thank you.
I think in the Madden case, Schwartz didn't have access to Westlaw classes. That's the reason he did it. And I think there might be something you could do in class about that. How am I going to verify quotes? They're used to being trained on Westlaw classes.
Right.
And a lot of times, sole practitioner or small practitioner doesn't have that access. So he decided to rely on ChatGPT.
Right. And if I remember, he was also dealing in a situation where he was a tort attorney and he understands tort law in New York really well, but this was a case where he had to combine New York tort law with international airline legislation that limited, claims against international airlines or against international flights by airlines. And because he didn't know that federal law, he didn't have access to that federal law in Westlaw, and that's when he turned to ChatGPT. And that's also something I emphasize to students. It's like, you're new to the law. I know attorneys who've been practicing in the same jurisdiction for 10, 20 years. They're able to spot errors immediately. If any little thing goes wrong, they're like, I've never seen that before. Nope, you don't have that advantage. Thus, this will take you longer to deal with. That's okay. You need to justify that to your supervisors that it's going to take you more time to verify these things. And the end result is that you won't have these errors when this goes to court. At least I hope that's what they're able to do. Yes?
So at our library, we have a lot of public patrons and we've had like biases and things. And it's kind of an uphill battle explaining why, maybe that. Do you have any advice on how we can take this for completely unfamiliar law?
I mean, I think if you can explain Rule 3.3 in a very layperson-centric way, just saying when you go to court, you are certifying that the things that you filed, that the things you say on the stand, etc., are true and actually exist. I think the big part would be convincing them these are certified ways of improving your filings that will find and fix your citations. Because, of course, they're worried about, I want to go in and win this case. So if you can convince them, particularly one thing you might want to do is look at the AI tracker by the French lawyer and look at all the cases for pro ses. Now, judges are pretty lenient with pro ses, but if there are cases where a pro se enters multiple filings that has multiple errors, even they will reach a point where they say, you need to withdraw this and refile, or I will dismiss this case against you, or I will give judgment to the other side. So there are real stakes for pro ses, just like there are real stakes for lawyers. So I would hope that some measure of carrot and stick would convince them to, you need to work on this a little bit more, because you don't want to tick off the judge. You don't want them to find that if your argument is otherwise has merit, but because you made all the stakes and the judge will find against you, that would be a shame. That would not be justice for your cause. I think is how I would try to explain it. Oh, good. Yay. Any other questions, concerns, comments? Anything I can do to improve my process for people who are already doing this? Yes.
There was a program at Seal by Emily McCutcheon Halliburry, I can't say her name, where she gives her students, she creates a 5-page brief that's full of hallucinated citations, bad quotation, all the things you mentioned, and gives her students 20 minutes to try to clean it up.
Okay.
And they say, I can't even read a 5-page brief in 20 minutes. And so they understand the time constraint and how people do this stuff late at night when they're in a hurry, and how they have a better sympathy for how it happens.
Cool. Yeah, when I've done the in-class exercise, they usually have 20 to 25 minutes to find the errors. Of course, the problem is if you put it in one of the brief analyzers like Westlaw, it takes 30 minutes to run. So that can be a little frustrating, but I think that's also useful for how time pressures contribute to this. Rebecca.
One other thing that I have had them do, and I think we've talked about this, so maybe you've done it as well, is look at some of the explanations from the attorneys. Like there was a And she goes through like kind of like what happened, and she like dissects all of the mistakes that she made, and I think it's kind of interesting to see like maybe gives a little bit of sympathy for or like understanding, although still after they read that until they did it themselves, they were still like, come on, like just read the cases. But then like I think it helps them to figure out like what is actually happening, like how do they occur.
Right. And I think that's a good point. In fact, what I'm thinking about doing for this fall, because I'm actually teaching AI and ethics in the same class, is having them perhaps role play as maybe bar discipline or as a judge saying, all right, I want you to watch part of this oral argument and I want you to look at the filings and consider, if there's already been a sanctions ordered, do you agree with the judge and why? Or, if you're acting as, bar discipline, whether or not this person should be suspended, reprimanded privately, reprimanded publicly, etc., and give justification for that, and whether or not you have sympathy, whether or not you believe that this was a one-time error, whether or not you believe the law firm needs to upgrade its policies. I don't know if you've all heard, LA is strewn with billboards for personal attorneys, and one of the biggest ones, Morgan & Morgan, which is nationwide. One of their attorneys got in trouble in, I believe it was Wyoming. They were pro hack vice for a client suing Walmart. And it turns out that they and another firm that was outside of the local jurisdiction had filings that included AI errors. They were reprimanded, sanctioned, kicked off the case. Recently, the same attorney from Morgan & Morgan, one of the sons, tried to enter an appearance for a major case in Massachusetts regarding Harvard Medical School and thefts from the morgue. You can imagine what they're stealing from the morgue. And the judges said, no, we don't know that you won't do the same thing here that you did in Wyoming. You haven't shown us that you've improved your processes to show that you won't have these AI error-ridden filings, so you cannot participate in this case. If you have Florida clients, that are affected by this, they need to find another attorney, but it's not going to be you. So, the repercussions of this are growing wider and wider. And I feel like hopefully if we start teaching this, that it will help put a stop to it. Because right now, attorneys who are already out in the world don't seem to be learning the lessons. Any other questions? Yes.
Actually, one sort of follow-up comment and then also a question. I think you just said students must just read the cases. And your point about Westlaw access. One thing, at one point I analyzed several most recent cases on the Damien Charles database and found that generally I am particularly prone to hallucinating those unpublished Westlaw citations, 2025 with deadly wells, string of numbers, which of course if you don't have access to Westlaw, you can't tell if it's even a real case or not. You can't check it and read it, so that's sort of a thing that's on Westlaw now that AI is fond of making it less hard. So it doesn't do the Lexis ones as much, just the Westlaw ones. My question though was about sort of dovetailing this with other learning objectives. I know that certainly when I was in law school, I was not reading actually the court filings, and there's even like seeing what's actually filed, even seeing a full opinion when it hasn't been excerpted from the casebook, is itself kind of a skill, and it can be kind of intimidating for students. So I was wondering if when you do this, do you sort of blend it, your dockets class or your filings class? Do you wait to introduce it until students exposure to that? Like how do you work with that? The fact that filings themselves are kind of unfamiliar.
Mostly I use pretty short filings. I'm not using cases that are like 25, 50 pages long. So most of them are like under 10 pages. And it's usually introduced after they've taken case law, after they've done dockets, after they've done public records. So it's not too much for them, I hope. But that's not something I've considered, that they, and because this is an upper division class, I usually figure at some point they've read an entire case. But perhaps that's something I should ask. Have you read an entire case before? If they're just used to case books where they're reading excerpts and not the whole thing. So thank you for that. Anything else? If not, thank you so much for being here. Thank you for staying, and I appreciate your questions and comments, and I hope you have a very wonderful rest of Cali.